Hello, everyone, and welcome to today's live webinar. Thank you for joining us, and for those of you who have had the opportunity to meet me, I am Natalie Gill, one of the LL.M assistants here at Florida Coastal, and for those who I have had the pleasure of meeting, welcome, and thank you for joining us in today's webinar. Before we begin today's presentation, I want to remind everyone that today's webinar is being recorded and to please mute your microphones until you are ready to speak. Please feel free to use the chat feature as well if you want to ask questions, public or private. And we will also be emailing everyone who registered for today's event a slide of today's presentation, as well as a recording and an outline provided by Professor Scales. Today we welcome Professor Scales. She joined Florida Coastal School of Law faculty in 2001 and served as the Director of Lawyering Processes Program in 2004 to 2013. She is currently teaching professional responsibilities this fall semester. Professor Scales holds a Bachelor of Science from Florida State University and a Juris Doctor from the University of College of Law, where she graduated with honors. University of Florida College of Law, where she graduated with honors. She practiced litigation for 7 years with Rogers, Towers, Bailey, Jones, and Gay, PA, and Marks, Gray, Conroy, and Gibbs, PA, prior to joining the faculty. She has also presented at conferences of national organizations on legal ethic issues and has helped students prepare for the multi-state professional responsibility examination. Professor Scales is a member of the Florida Bar and is admitted to practice before all Florida courts, as well as a U.S. District Court, Middle District of Florida. Please join me in welcoming Professor Scales.
Hello, everybody. How are you doing today? Okay, so I have taught PR, professional responsibility, PR, and helped students who are preparing for the MPRE for years now. And I have a pretty good idea of what it's going to take to help you pass the exam. So I would like to share that information with you today. So let's get started. Okay, so the MPRE is the Multi-State Professional Responsibility Examination. And it is given by the National Conference of Bar Examiners every year. And most states in the country require you to pass it. It's an ethics exam in order to be admitted to the bar in their state. The exam is given 3 times per year in March, August, and November. The next exam that I'm preparing my JD students for right now is on November 5th, so we're getting really close. We have 2 weeks to go, and I think they're really excited about it. I think they're doing a great job. Registration for that exam has already closed, so you can't take the November 5th exam, so the next exam you'll be able to take is in March. If you would like to register for the exam, for the next exam in March, you go to ncbex.org. The exam is $84, but if you register too late, then the cost doubles. So you want to make sure you register early. And the ncbex.org website has all the information that you need to register. So the exam is 60 multiple choice questions. They have 4 answers each. And 50 of the questions count. 10 are experimental. So if you get some kind of wacko questions or you get a lot of questions on one area, chances are those are the experimental questions, and they're not going to count towards your score. You have 2 hours to take the exam of 60 questions, so that's about 2 minutes per question. And if you practice enough, that typically isn't a problem for students. You should be able to finish the exam in the time permitted. The exam is scored between 50 and 150, and in order to pass, in all states, you have to get somewhere between a 75 and an 86. Some of you are taking the California bar, and for California, you have to have an 86 MPRE score. In Washington State, you need an 85 MPRE score. And in Florida, where I am, you need an 80 MPRE score. All right, so what does the MPRE cover? Well, it covers 2 sets of rules. The majority of the test covers the ABA Model Rules of Professional Conduct. So this is a model code, and each state adopts the code with revisions that it would like. So for instance, most states adopt most of the code, and then they make revisions where they would like to. So, for example, I'm familiar with Florida since this is where I live. Florida has made a lot of revisions to the contingency fee rules and to the advertising rules. So in whatever state you're practicing in, you're going to want to make sure you're familiar with the rules for that state. But what the MPRE covers is the model rules. So for the MPRE, all you need to know is the model rules. So I've included on the slide the link to the model rules, and you can download them and print them there. The other body of rules that is covered on the MPRE is the ABA Model Code of Judicial Conduct. These are the ethics rules that judges are required to follow. So in order to do well on the exam, you need to be very familiar with both sets of rules that are listed on this slide. So I recommend you get a hard copy. It's just easier to study that way, and there are two ways to do this. You can print them from the links on the prior slide, and when you print them, you need to print not only the rules, but the comments to the rules. The comments to the rules are often longer than the rules themselves, and the test makers love to test from the comments. So it's critical that you're familiar not only with the rules, but also with the comments to the rules. Or what is even easier than doing all that printing, if you don't want to do that, is you can purchase a used book from Amazon that has both sets of rules. I recommend the Selected Standards on Professional Responsibility by Morgan and Rotunda. And you can find it used on Amazon usually for less than $5, and that might be the easiest way to just grab a hard copy of the rules. Okay, so let's talk about how to prepare. If you're in my PR class in the LLM program, then certainly study my slides, study the rules and the comments to the rules that I mentioned, and do the practice questions that are contained in the PR course. If you are not enrolled in my LLM PR course, don't worry. There are plenty of ways you can get prepared. I would recommend you sign up with MPRE for the free MPRE course at www.barbary.com. I've included the link. And there is an outline there that you will want to study, and it's really good in my opinion. And I would recommend as you're reading the outline, when you reach a rule, then you go to your rule book or your printout of the rules and read the rule and its comments at that time. So you're reading the outline along with the actual rule. Also on the MPRE website, there's a 3-hour MPRE review video that is very helpful. The link is on the screen, but I'm also going to email the link to everyone who attends this webinar so you can watch the review. Also, there's a fill-in-the-blank outline that you fill in while you're watching the online review, and that's really helpful. So I'm also emailing that to everyone who attends this webinar today. So, go to MPRE, watch the review video, and fill in the outline that I'm going to send you. Also, I prepared an outline of the course, which I call the golden ticket, and I am emailing that to you as well if you are registered for this webinar. And that is my outline of the course. So the first half of the outline, I simply go through each of the rules in order and try to put them into more simple language to help you understand them. And then the second half of the outline is just a list of frequently tested issues and topics that I see tested a lot that I just wanted everybody to have in one simple place. So you'll be receiving that email as well. Okay, so the best way to prepare for the exam, first, read through the outline and become familiar with all of the rules. They're not that voluminous, so it's a doable amount of work. But the first thing you need to do is, for instance, read the MPRE outline and read all the rules and all the comments and try to get a basic understanding of the rules. Then move into practice questions. One of the best ways in the experience of the students I've worked with for years, one of the best ways, frankly, to learn the rules is to do practice questions, because then you can see the rules applied in the way that they're going to be applied on the exam itself. So I wanted to share with you there are many, many resources out there with question banks for practice MPRE questions. So on the MPRE website that I mentioned, there are probably 250 questions. Kaplan has a free MPRE review, and I've included the link there so you can sign up for that, and they have review questions. Also, CMIS has review questions. I've included the link for CMIS. Also, BarMax has free questions. So if you have an iPhone or an iPad or an Apple product, you can access the BarMax app in the Apple Store, and you can do free questions on your iPhone or your iPad. They don't have it on Android phones yet, however. You can also access BarMax on your computer, and so I've included the link. Also, you could just Google BarMax MPRE and you'll find it. And finally, the last free resource I'm aware of is the Regos MPRE review, and it is free as well and contains practice questions as well. So a lot of students really like BarMax because they can do it right on their iPhone or iPad. So when you have some free time, you can do some practice questions. BarMax also divides the course topics into about, I think it's about 10 to 20-minite webinars, so you can watch a review on a topic and then go do practice questions on that topic. So I would recommend you access all these free resources to find practice questions and just practice, practice, practice. All right, so if you want to sign up to take the MPRE, go to ncbex.org. It will give you all the information regarding the exam. And it also has 15 free practice questions there. And also on the ncbex.org website, there is a study aid store, and you can purchase a practice MPRE exam there for $35, and I would recommend you take their practice exam as well, since they're the actual test maker. All right, so let's talk about the substance of what you'll be tested on. And so I'm just going to do a review of kind of the most commonly tested rules. So the first thing is, when you see a question, make sure you note whether a rule says you must or shall do something or you may do something. If you must or shall do something, you will be disciplined for failure to follow the rule. But if the rule says you may do something but you don't have to, then it's within the attorney's discretion and the attorney will not be disciplined for his or her decision. All right, so some hot topics. Let's start with Rule 1.1, competence. This rule says that you have to be competent in representing your client. So what does that mean for brand new lawyers? Because we're probably not competent to do much of anything when we first graduate, right? So what it says is you can become competent on a new area of law through self-study or through association with a lawyer who is competent. So if you got a question that said, hey, this is your first DUI case and you don't know what to do, are you going to be subject to discipline if you take the case? The answer is no, so long as you become competent through studying about DUI or associating with a lawyer who already knows about DUI law. Rule 1.2, allocation of authority. The important words in this rule are, it states that clients get to determine the objective of litigation. That means the big decisions relating to litigation, such as whether to settle a case or go to trial, or in a criminal context, whether to plead guilty or not. So the client has the authority to make those decisions. The attorney gets to decide the means for achieving the objective. So that would be the day-to-day things you have to decide, such as what discovery requests to make or how to respond to discovery. As far as things that cost a lot of money, like expert witness fees and taking a lot of depositions and such that would cost a lot of court reporter fees, they say kind of defer to the client on things that are really expensive and make sure the client can afford it. And it basically says if the lawyer and the client can't agree on the means for achieving the objective, then normally all it says that to help us, which frankly isn't very helpful, is that usually the client's going to defer to the attorney's authority. And if you can't, I guess then you can eventually part ways if you can't reach a resolution. But the main thing you'll probably be tested on are that clients get to determine the objectives of litigation and lawyers get to determine the means for achieving those objectives. All right, Rule 1.5 and 115. These are the two rules that deal with fees. So 1.5 says that a fee has to be reasonable, and it gives the factors for determining whether a fee is reasonable, such as the amount of skill required to do the case, the amount of hours required to do the case, customary fees in your locality. So there's just a laundry list of things that you have to make sure are in place such that fees are reasonable. Now, a common question you'll get on the MPRE is it'll say, if you had taken this case on an hourly rate, you would have earned $10,000. But you took it on a contingency fee basis and you earned $250,000. Is that a reasonable fee? yes, contingent fees can be much higher than an hourly fee would have been because the lawyer is taking a risk in doing a contingency fee case, because if they lose the case, the lawyer is going to get zero. Speaking of contingency fees, contingent fee agreements, according to Rule 1.5, must be in writing, and they must state what percentage the client's going to get and what percentage the lawyer is going to get, and they must state how expenses will be deducted from each party's share. So, for example, is the client going to have to bear the cost of all the expenses, or are the lawyer and the client going to split them up? So all that needs to be set forth in a contingent fee agreement. Now, surprisingly, fee agreements that are not contingent fees, such as an hourly rate agreement or a flat fee agreement, surprisingly, those fee agreements do not have to be in writing. So just be sure to know that contingent fee agreements have to be in writing, but other fee agreements don't. Also, a commonly tested issue is, when do you have to explain your fees to the client? You don't have to do it at the very first meeting with your client, because sometimes you're just wanting to build rapport with your client at that first meeting. But it says that you do have to explain your fee structure to your clients within a reasonable time after you commence representing them. So, sometime in the first few meetings, you probably need to go ahead and explain your fee arrangement with your client. All right, the other rule that relates to fees is Rule 1.15, and this is the trust accounting rule. So when a client pays you a retainer, you do not have the authority to move that money into your personal account or your business operating account until you earn it. So when you receive a retainer from clients, you put it into a trust account, and then as you earn the fees each month, you send a bill to the client, and then within a reasonable time after that, you move the fees from the trust account into your personal account. You don't want to commingle your personal money with the client's trust account money. That will get you in big trouble, and is probably the most common way that lawyers get in trouble, is not having good bookkeeping or misusing their trust account. So you can't use one client's trust money to pay for things needed for another client. Like, let's say you need to pay for an expert witness for another client. You need to keep a ledger of, within the trust account, which client's money are which. Okay, what do we do with the interest off these trust accounts? So they allow us to set up these accounts. These trust accounts are called IOLTA accounts, which means interest on lawyers' trust account. And the United States Supreme Court has said that the interest on these accounts gets paid to do pro bono work to help the poor. So that's who gets the interest. But so that we don't have to open up a new account for every single client, because the bank fees for that could be really, really large, they let us put all the clients' retainers into one account, but we just need to keep track of within that account whose money is whose. Also, you're not allowed to put your own money into the trust account. That's improper commingling as well. So you can put in enough to pay the bank fees, if any, on the account, but other than that, you can't put your own personal money into the trust account, nor can you take trust account money out until you earn it. What if there's a dispute over money in the account? Well, the rules say that, so let's say a client gave you $10,000, and at the end of the case, you think you earned $8,000. Your client says, no, I think you only earned $4,000. Well, let's use $5,000. That will make it better math for my problem. So the client thinks that you earned $5,000. You think you earned $8,000. So you can take the $5,000 out because there's no dispute. The client agrees you've earned that. And you can send $2,000 to the client because the client says that because you agree you've only earned $8,000 of the $10,000. So the $2,000 isn't in dispute either. You've got to keep that $3,000 that's in dispute into your trust account until the dispute is resolved. The rules are silent as to how to resolve the dispute, but they do say you just need to maintain any disputed funds until there's a resolution as to that money. All right, confidentiality. So this is a very heavily tested topic, Rule 1.6. So a lawyer shall not reveal information relating to the representation of a client. Note those words relating to. So this is very, very broad. It could be information you've learned from your client, or information that you've learned from a third party, or anything you've learned. Maybe you've learned during a case that the attorney on the other side is unethical. This is all information you've learned relating to the representation of a client. And the start of the rule is that you can't reveal that. You've got to maintain confidentiality unless 3 situations are present. 1, the client gives you informed consent. 2, the disclosure is impliedly authorized in order to carry out the representation. Or 3, the disclosure is permitted by paragraph B. So anytime you get a question and it's asking whether you're going to be subject to discipline for revealing any type of information, you want to ask yourself these 3 questions. Has the client given consent? Is the disclosure impliedly authorized to carry out the representation? Or is it permitted by paragraph B? Let me give you examples of things that are impliedly authorized for you to reveal to carry out representation. When, let's say you need to talk to a doctor because you have an elderly client that you feel might have diminished capacity and you're wondering whether to appoint a guardian for them. So you go and you talk to a doctor about your client. Okay, you're trying to help your client. So that would be impliedly authorized in order to carry out the representation. Another example would be you need to talk to an expert witness about your case. Okay, so you're going to have to reveal things relating to the representation in order to help your client. Or you're in settlement negotiations. Obviously, you're going to have to talk to the other side about things relating to your case in order to settle. So in those situations, if you get any kind of a hypo where the attorney needs help from someone in order to carry out the representation, then it's going to be okay if the attorney breaches confidentiality. Another common example or question you'll get is the attorney isn't sure how to handle like a discovery issue related to a case. So the attorney calls up a mentor attorney or a law professor to seek some guidance. Again, that would be impliedly authorized in order to carry out the representation. So you can reveal confidential information in order to basically help your client, and that's okay. So the third way is if disclosure is permitted by paragraph B. So paragraph B contains many exceptions where you can breach confidentiality. So first, to prevent reasonably certain death or substantial bodily harm. So if your client comes in and says, I'm going to kill my spouse or my neighbor tonight, then you can go tell whomever you need, be it the neighbor, be it the police, in order to prevent death or substantial bodily injury. But remember, this is a may rule. So let's look back one slide. 1.6 says that you may, well, actually it's not on the slide, but it says you may, under Part B, disclose information to the extent reasonably necessary. So I would go in your rule book in 1.6b and circle the word may. So for example, let's say a client comes in and says, I killed someone and I buried them behind the mall. Okay, and you know that the victim's family is looking for them. May you reveal that? Well, the rule says no, because revealing it isn't going to prevent death or substantial bodily harm because unfortunately the harm is already done. So you can't reveal where dead bodies are buried, but you can, if you want, go warn someone if your client tells you they're about to, or if any third party, frankly, if you learn related to a case that someone's going to suffer reasonably certain death or substantial bodily harm, you can go warn them or tell the police or do whatever you want, but you don't have to. It's within your discretion. Also, you can breach confidentiality to prevent a client from committing a fraud, a financial fraud, or injury to the financial interests or property of another, but only if they've used your attorney services in furtherance of the substantial injury to the financial interest. So there's a little difference between bodily harm and financial harm. You can warn people if you think bodily harm is coming soon, but for financial harm, you can only breach confidentiality and warn people of it if the client has used your lawyer's services in furtherance of the harm. So that's an extra requirement for financial harm. All right, number 4, to secure legal advice about your compliance with these rules. What that means is to get a legal ethics opinion. So let's say you're not sure whether some action you're planning to take would violate the ethics rules, you can breach confidentiality to get an opinion. Number 5, to defend yourself, okay? If someone says, I'm going to sue you for malpractice or turn you over to the state attorney's office for prosecution, or I'm going to report you to the bar for discipline, from the minute they say that to you, you can breach confidentiality if needed to defend yourself. You don't have to wait until the accuser files a formal complaint or claim against you. From the minute they make the allegations, you can breach confidentiality to defend yourself. And finally, under number 7, to detect and resolve conflicts of interest. So let's say you're moving from one firm to another, and you want to make sure the new firm isn't on the other side of cases you've worked at your prior firm. Then you can reveal confidential information enough to make sure that you don't have any conflicts of interest. So that's a nice segue into conflicts of interest. So conflicts of interest is a very heavily tested area, and all the conflicts of interest rules are contained between rules 1.7 and 1.12. So let's review those. First, rule 1.7. Okay, you can never represent one client if your representation of that client will be directly adverse to another current client, even on unrelated matters. So let's say you're representing Coca-Cola in a breach of contract claim, and then another client comes in and wants you to sue Coca-Cola because a Coke truck hit their client and it's a personal injury claim. So the claims have nothing to do with one another. But your firm and you can't be representing Coca-Cola in case 1 and then suing Coca-Cola in case 2 unless the client consents. Okay? So and the reason is that we don't want Coca-Cola to feel that we are being disloyal to them. So on the one hand, they're paying your bill for representing them, and on the other hand, your firm or you are suing them. So if you want to do that, then you have to, first of all, reasonably believe that you will be able to provide competent and diligent representation to each affected client. So you see that under 1.7b1 on the slide. Okay? And under Part 4, each affected client has to give informed consent. So if you're representing Coke and suing Coke at the same time in 2 different cases, and you first of all believe you can competently represent them both, which I'm not sure how you could believe that because it seems like you might be limited in your representation of them in the one case by virtue of your loyalty to them in the other case. But assuming you got a hypo that said you do think you can competently and diligently represent 2 clients at the same time, and assuming you can get the client's informed written consent, then you can do the multiple representation of current clients who are in conflict. The one exception to that is in 1.7b3 that you see on the slide. If the representation involves the assertion of a claim by one client against another in the same litigation, then it is not consentable. Okay, so for example, you can't defend Coke in the same case where you're suing Coke. So let's say the breach of contract case. You can't be representing Coke and saying, no, they didn't breach the contract, and then representing the adverse party at the same time saying, yes, Coke did breach the contract. You would seem to be schizophrenic. Okay, so one of the only conflicts that isn't consentable is 2 adverse parties in the same litigation. That's not consentable. But otherwise, if you have 2 current clients and you believe you can competently represent them both, and they'll give you informed written consent to represent them despite any conflict, then you can represent them both. So really, if you get any conflict questions, if there is any time you're given a hypo where something you're doing in one case might be limited by your loyalty to another current client, that's a conflict. But if you can reasonably believe you can competently represent them both and get informed written consent, then the conflict could be consentable. And on the MPRE, you'll see all different kinds of factual scenarios where you might have a conflict of interest between 2 current clients. I saw one recently where you were representing a judge who thought the judge was going to be disciplined, and at the same time you had another case where you were representing a client who was in the judge's courtroom, the same judge was presiding over your other client's case. Can you do that? Well, if you think about it, that could cause a conflict. Because what if you don't like what the judge is doing to your client in the case where the judge is presiding over your client's case? So then you're going to have to be hard on that judge. Well, except the judge is paying you in the other case where you're representing the judge in the disciplinary proceeding against the judge, or maybe you're learning things in the disciplinary proceeding that you could use against the judge in your other client's case. So you've got a conflict. But because both clients aren't adverse to each other in the same litigation, the conflict is consentable. So long as the hypo said that you feel competent to represent both clients at the same time, and they'll give you informed written consent, then it's okay. All right, let's talk about former clients. Similarly, if you've represented a client formerly in the past, basically what the rule is you can't later represent anyone where you could use information you learned in the prior matter to harm your former client in the current matter, because that would make you seem disloyal. Okay, so when you're representing someone, if you learn something from them, then you can't later use it against them. And that's kind of the bottom line of Rule 1.9. The actual wording of the rule says if you formerly represented a client, you can't later represent someone in the same or a substantially related matter. And what they're saying is they don't want you to use information you learned in the first case if it's substantially related to the second case, because then you could use it against the client if you're adverse to your former client in the second case. Again, it's consentable. So if your former client will give you informed consent, then you can use the information against them, but they would need to give you informed consent to do that. All right, let's talk about if you move from one firm to another firm, okay? If you are in firm one and you have acquired information, if you look at Part B2, you've acquired information protected by Rules 1.6 or 1.9c. What they're saying is basically you worked on the case at firm one, you got confidential information about the case while at firm one, and then you change firms and you go to firm two, okay? Then you're conflicted out, okay? So unless you can get the former client's informed consent, the firm one client, you can't have worked on a case at firm one and then go to firm two and be on the other side of the case. You're conflicted out unless you can get the former client's consent. Okay, and then what about the rest of your firm? Okay, normally if you're out, your whole firm is out. So your conflicts of interest are imputed to your whole firm unless they're personal. So let's say you can't work on a case because the adverse party is your wife or your mother or one of your relatives, or because you're having sex with the client, because you'll learn when you read Rule 1.8 that you can't be in sexual relationships with your client. Those are personal conflicts where you're out for a personal reason because you know the attorney on the other side or something like that, and that might cause you to be disloyal to your client. So, for example, if I'm representing the plaintiff and my spouse is representing the defendant, chances are I'm going to be limited in my loyalty to my client because of my loyalties to my spouse. That's a personal conflict, and that conflict isn't imputed to my firm. So other members of my firm could represent my client against my wife because they're not going to care as much that she's my wife. Unless you got a hypo that said they did, but generally speaking, that's a personal conflict that's not imputed. So what happens when I worked on a case at firm one and now I've gone to firm two? Well, what they do, they've loosened up the rules because lawyers move around so much. And what they've decided is that I can be screened. I'm the conflicted lawyer who's gone from working on the case at firm one and knowing confidential information about the case there to going to firm two that's on the other side. So I can be screened out, and firm two can continue with the representation. So what that means is we give written notice. You don't need the consent of the client from firm one. Rather, you simply give them written notice and a certification of how you've complied with the screening rules. And it'll say things like that the conflicted lawyer won't have access to the files, won't discuss the case, won't share any fees from the case that would incentivize the lawyer to talk about the case, and will just be completely screened off from the case. Now, let me give you another example. What if at firm 1, a lawyer never worked on the case? They didn't know any confidential information about the case. They knew nothing. Then that lawyer goes to firm 2, who's on the other side of the case. In that situation, there is no conflict at all, so nothing has to be done. You don't need the client's consent, and you don't need to screen the lawyer. The only time that consent and screening come into play are if the lawyer who moved from firm 1 to firm 2 worked on the case at firm 1, had confidential information about the case at firm 1, and then moved to firm 2. The lawyer is out unless he can get the consent of the client, and the lawyer's firm may only stay in if it screens the conflicted lawyer out, doesn't allow the lawyer any access to the case, nor any fees from the case, and you give written notice to the affected client of what your screening procedures were. And then firm 2 can stay in. So screening, if you get a question where screening is one of the options, screening almost always is only going to help firm 2 to be able to stay in a case when a conflicted lawyer arrives to work at firm 2. You can screen the conflicted lawyer out, and firm 2 can stay. Screening is not going to be the correct answer for helping firm 1 if they have a conflict. All right, let's look at another aspect of 1.10b. What if you leave firm 1 and take your clients with you, or you die, or a lawyer in firm 1 die? Okay? Can firm 1 then be adverse to the departed lawyer's clients? And here's the rule on that. So let's say you are a lawyer at firm 1, and you leave and you take all your cases with you to your new firm, firm 2. Okay? If any lawyer remaining behind at firm 1 knows about those cases, then firm 1 cannot sue or be adverse to the clients who left the firm. Okay, if there's anyone left behind who knows about the cases, because again, it's just loyalty. If there are lawyers left behind who worked on the case while at firm 1, and then a lawyer takes those cases and leaves, firm 1 shouldn't then be able to be adverse to that client and use that confidential information against the client who left. But if the lawyer who leaves takes all the cases with them and nobody's left behind who knows anything about the cases, then sure, firm 1 should be able to be adverse to those departed clients because nobody there knows anything, so there's no problem with loyalty. I have seen one question where the way that the lawyer left was that he died, and then all the clients went to a new firm after the death of the lawyer, and the question was, can the firm 1, where the lawyer was before he died, go against all the deceased lawyer's former clients? Yes, so long as nobody at firm 1 knows anything about the cases. So it's the same whether cases leave a firm because a lawyer dies and the clients themselves move on to other lawyers, or if it's because a lawyer leaves and takes his book of business with them. So long as nobody's left behind who knows about the cases, then the prior firm can actually go against those clients who departed with the departing lawyer. All right, 111 and 112 cover former government attorneys and former judges and ADR neutrals. So what these rules are talking about is if someone is a former government attorney and then they go into private practice, or they're a judge or any kind of an ADR neutral, meaning alternative dispute resolution neutral party. The most common is a mediator. So someone that's neutral in helping parties resolve disputes. It could also be an arbitrator. This rule also applies to judicial law clerks as well. So if you're a judge or, let's say, a mediator or a judicial law clerk, and then you leave and you go into a private firm, okay, the rule is if you participated personally or substantially in the cases while at your prior job, then you can't work on those same matters, and the word matter is very significant in the rule. You can't work on matters you participated personally and substantially in when you leave government or your judgeship or being a mediator and go into private practice without the consent of the affected party, okay? But your new firm can work on those cases as long as they screen you out. So it's the same rule as we saw in Rule 1.10. So if you were a judge on a case, then you decided not to be a judge anymore and to go back into private practice, any case that you presided over, you can't be involved in that case at your new firm, but your new firm can so long as they screen you out. Okay? Unless you can get the consent of all the parties. Another example, let's say you were a mediator on a case, and then after the mediation it doesn't settle, and one of the clients says, oh, I was really, really impressed with you, I want to hire you. Okay? You can't later represent any of the parties to the mediation without the consent of all of the parties if you participated personally and substantially. But someone at your firm could represent them as long as they screen you out. All right, 113 in Sarbanes-Oxley. Pardon me, Sarbanes-Oxley. So these rules are similar. 113 covers if you have an organization as a client, like a corporation. And Sarbanes-Oxley is a federal law that came up after all the Enron scandals with the SEC. And basically the rules give us our reporting obligations if we are involved with a corporation, and if it's a corporation that's exchanged on the Securities and Exchange Commission, then Sarbanes-Oxley is a federal statute that applies. And it tells us what to do when we see that an employee is doing something that's going to harm the corporation. And basically, I came up with this rule called the must, must, may rule. And if you can remember must, must, may, you can usually answer these questions correctly because they're going to be asking you, who do you have to report to, and is your reporting duty mandatory or discretionary? So under both scenarios, Rule 1.13 would be for any corporation or organization. So that's on the left, and then Sarbanes-Oxley would be for those corporations exchanged on the Securities and Exchange Commission. So first, you must report to somebody. If it's a 113 organization, which would be any organization, not-for-profit or corporate, it says you must report to a higher authority. So let's say the vice president or the president. If they don't do anything about the misconduct that you report, then you must report to the highest authority. In most corporations and organizations, that's going to be the board of directors or some component of the board of directors. If they don't do anything, then you may report to others as necessary. So this is where you get to tattletale outside of the organization. So you must go higher, you must go highest, like to the board, then you may report outside, and that's up to you. If you don't want to, you don't have to, but you're not going to get disciplined for breaching confidentiality if you go tell someone in order to protect the corporation. Under Sarbanes-Oxley, it's a little bit more specific who you have to go to. You first must report to the CLO, which is the Chief Legal Officer. So companies that are traded on the Securities and Exchange Commission have to have a Chief Legal Officer. So first, you must report wrongdoing to the CLO. If they don't remedy it, you must go to the board of directors or some component of the board. And then it's up to you whether to report outside. So in both of them, they say you must go to the top of the organization. Then you may report outside if you want to. So I see a question. Says, I'm in a firm and one of the lawyers cannot work on a case for whatever reason. I have to screen him out, but I can lie. How to be sure the lawyer is screened out? How the adverse party can say she doesn't agree for this firm to be adverse attorney because the lawyer who works there should be screened out. So in a case like this, if it's a litigation case, you can go to the judge and the judge can determine all of these things. So the parties have a right, if you read through Rule 1.10 of the screening requirements, the parties have a right to know what you are doing to comply with screening, and they also have a right to have the court review it. So if the parties are really unhappy that the screening isn't being done properly, then they can go to the judge and try to get the firm removed from the case. So good question. All right, let's talk about perjury, Rule 3.3. First, when do we have to be the perjury police, okay? So what perjury is knowing that someone's lying under oath. So it could be at a hearing or a deposition or at a trial. We as lawyers cannot be a part of perjury because we have a duty of candor toward the court or the tribunal. So first thing to remember is your obligation to report perjury only applies until your cases are concluded and the time for appeal has run. Okay, so if you got a question that says you found out in one of your cases from 6 months ago that perjury occurred, do you have to do anything about it? The answer is no. Okay? Or you find out there was perjury by a witness or a party in a case you had nothing to do with. Do you have to report that? No, never. You only have a duty to be what I call the perjury police while your cases are ongoing. So the perjury rule says you shall not offer any testimony you know is false. Okay? Now, when you ask questions knowing the answers that are going to be given, either from your client or from any witness, are going to be false, then you need to, you can't be involved in that. You will be disciplined for being involved in that perjury. So if you know testimony that you are eliciting through your questioning is false, you cannot be involved in that. Now, what if you only reasonably believe the evidence that's offered is false? Then what do? Then you have discretion. The rule says you may refuse to offer evidence you reasonably believe is false. So, very important words in this rule are, if you know it's false, you have a mandatory duty to not ask the question or be involved in it. If you only reasonably believe it's false, then you can ask it or not, and that's your choice, with one exception. Criminal defendants have a right to testify on their own behalf. It's a constitutional right. So if you know a criminal defendant is going to lie on the stand or perjure himself, you can't be involved in that. But if you reasonably believe a criminal defense client will lie and he wants to testify, you have to let him. Okay, so in a civil case, or if it's any witness who's not a criminal defendant, and you reasonably believe they're going to lie, you can choose not to be involved in that and to ask those questions. But for a criminal defendant client, you've got to let them testify if they want to, unless you know they're going to lie. So what do judges do when this happens? So here's how it typically comes up. So you are questioning your criminal defense client, and either before you question them at all or at some point during the questioning when you know you're getting to the part where they're going to perjure themselves, then you go up to the judge and take a sidebar. You say, Your Honor, I'm having an issue with my client, and I need to withdraw from the case. And the judge will know, what this lawyer is telling me is this client's about to perjure himself, and lawyers can't be involved in this perjury. So what some judges will do is have you take the narrative approach, or have the client, frankly, take the narrative approach, which means the judge will just have you sit down and will just let the criminal defendant talk and just say, is there anything you want to tell the jury? Or you'll just say some open question to the client on the stand, like, is there anything else you want to say to the court? And then you sit down and you're not involved in it. And it's kind of a way that courts can keep cases going, but keep lawyers from getting disciplined for engaging in perjury. Okay? Now, the DWR rule. I made up this name for the rule to help you remember what to do if a client perjures himself or is going to perjure himself. The D is dissuade them. So the first thing you want to do if you think they're going to perjure themselves or if they've already perjured themselves is try to dissuade them from doing so. And if they've already done it, you want to try to get them to get back under oath and change their testimony to the truth. Okay, so before you want to say, hey, I have legal ethics issues. If you're going to perjure yourself, I can't represent you. I can't be a part of it. Please don't do it. So try to dissuade them. If they've already done it, then you need to say, hey, let's get back on the stand and fix your testimony because I know you committed perjury. Okay, if that won't work, we go to the W, which is the withdrawal. That's where you go up to the judge and you say, Your Honor, I'm having a problem with my client. I need to withdraw. And the judge will know exactly what's going on and may or may not let you withdraw. The judge gets to decide whether you can withdraw. If withdrawal will cure the perjury, like for whatever reason it won't happen, then you're good and it's over. But if it won't, then you can go a step further and tattletale on your client and actually reveal the perjury to the court. So DWR. So before you go and tell the court about the perjury, first, try to get your client not to do it. Second, try to withdraw if it'll cure the problem. And if it won't, then you can reveal the perjury to the court, and you're not going to be in trouble for violating your 1.6 confidentiality duty. So it is important to remember that this Rule 3.3 trumps your 1.6 confidentiality duties. So this rule controls. All right, Rule 3.4, I named this rule the My Peeps rule because it talks about who can you tell not to voluntarily talk to the other side. Okay, you can tell your peeps, okay, if it's not going to hurt them. So your peeps, according to Rule 3.4, are your clients, relatives, their employees, and their agents. Former employees are not peeps. So you'll sometimes get a question that says, the other side wants to talk to your client's former employee. Can you tell the former employee not to talk to them? The answer is no. But you can tell a current employee not to talk to them or a relative, and that's fine, unless it's going to harm the person not to talk. So let me give you an example of that. Let's say the Department of Children and Families is investigating you for child abuse, and you live with your adult sister. Okay, if the adult sister needs to talk to DCF in order to defend herself so that DCF doesn't think the sister is the abuser, then you shouldn't tell the sister not to talk to DCF. But as long as it's not going to hurt the sister to not talk to DCF, you can tell her to stay quiet. All right, 4.3, dealing with unrepresented persons. All right, so the big thing here is I really don't care for the way that this rule is worded. It says you can't state or imply you are disinterested, okay? Turning that around to something I think might be a little more easy to comprehend is the other side must understand you're interested or you favor or represent the other side. So the best example that comes up often is a divorce where the parties pretty much get along. And so you've got to make sure the other spouse, if they're not represented, understands that you represent the spouse that you're representing and not them. Okay? Pardon me a minute. Sorry about that. Okay, so you can't state or imply to the other side that you're disinterested. So if you're representing a wife in a divorce and they pretty much agreed on everything and they want you to draft up all the papers and the husband is not going to be represented, that's fine, okay? But you can't let the husband think that you're neutral or that you're protecting his interests at all. You need to write a letter when you send over the settlement agreement that is very clear that states that I represent your wife's interests. I do not represent you or your interests. Also, the rule says you can't give legal advice to the other person other than you can tell them to seek counsel if you want to, but you don't have to. So usually what I would do in that situation is write a cover letter that says, hey, here's your divorce decree. I represent your wife. I don't represent your interests. I recommend that you have a lawyer look over this. Now, I didn't have to give that advice, but I can if I want to. And I like to cover myself in that way so that the other spouse could never come back and say, wait a minute, I thought you represented me. Nope, you don't want that to happen. So you've got to make sure to cover yourself and not, a lot of times the answer will be that you can't give legal advice to the other side. All right, Rule 7.1, advertising and solicitation. So this is a very ripe area for questions on the exam. So you want to make sure you understand the advertising and solicitation rules. And they are in Rules 7.1, 7.2, and 7.3. Okay, any communication, be it an advertisement or a solicitation, can't be misleading. Okay, so what types of things are misleading? The two most common things that are misleading are if you guarantee results or if you have an ad that says you've won $1 million for all these clients. That can mislead the public to think that you can get them $1 million too. So if you're going to say you won $1 million for a client, you're going to want to have a disclaimer that says that those results vary and, don't happen in every case. Otherwise, you could be misleading your client. Another way to mislead your client is you can't compare yourself to other attorneys. For example, you can't say, I'm the best criminal defense attorney in town, or I'm the best estate planning attorney in town, or I'm the least expensive attorney in town. unless you can objectively verify with data, which you usually can't. So no comparison saying you're the best, and don't say, I think, like, I guarantee I can get you off of your criminal conviction, or I guarantee, I can get you a great settlement, or if you hire me, you're sure to win. You can't say anything like that because it's misleading. Also, you can't show yourself on a commercial arguing before a jury if you've never had a jury trial. That would be another example of something that would be misleading. Okay, as far as advertising goes, no referral fee. Okay, that's where you start. You can't give anything of value for referrals. So it could be money or it could be like bartering. So let's say you hire somebody to do something for you and you pay them for it, and in return they're going to send you referrals. Okay, you're still giving that person something of value. You hired them to do something for you, and in exchange they're giving you referrals. Okay, the only way that you can get clients and pay money for the receipt of referrals is you can pay normal advertising costs. You can pay to have an ad in the newspaper or the radio or a billboard or whatever. Also, you can pay not-for-profit and qualified lawyer referral services. So remember N and Q. You can pay lawyer referral services their normal fees if they are either N, not-for-profit, or Q, qualified. You can also participate in legal service insurance plans. So that is where people sign up, and then if they ever need an attorney, one is provided for them. The legal service plans can directly solicit clients to sign up for the plan as long as they don't know they're in need of a particular attorney. So, for example, what a legal service plan can do is come to an employee benefits meeting where you're enrolling in medical insurance, dental insurance, and they can say, hey, we've got this legal insurance plan. If you want to sign up, sign up. That's cool. Or they can call people on the phone and say, we're a legal service plan. Would you like to sign up? That's cool. What they can't do is go down to the courthouse every day and, let's say, look at all the new criminal cases that have been filed or all the new family law cases that have been filed, and then call all those people knowing they need that type of an attorney and solicit them. That would be improper solicitation by a legal service insurance plan. They can only solicit generically in general. The other way you can get clients is through reciprocal referral agreements. These have to be between a lawyer and either another lawyer or a non-lawyer professional. They have to not be exclusive. They have to not be permanent or indefinite in nature. And the client has to be informed of the reciprocal referral agreement. So, for example, if you want to refer cases to a marriage counselor and in return they're going to refer cases to you, that's fine because they're a professional. You've got to be referring to more than one marriage counselor. It can't be exclusive. There's got to be some provision that at times you check the, how is it going, and it's not intended to be permanent in nature. And you've got to tell the client, hey, I'm going to refer you to this marriage counselor, but you need to know that I also refer to this other marriage counselor, and the marriage counselor refers clients back to me. So can you have a reciprocal referral agreement with your friend that owns a pizza parlor? No, because they're not a professional. Okay, so you can't say, hey, I'll send you pizza customers if you send me law clients. That's not going to work because it would violate. So you want to make sure you've memorized the requirements for a reciprocal referral agreement. Otherwise, you can't pay people for referrals. All right, let's talk about solicitation, okay? There are two categories of solicitation. The first is in-person live solicitation. So this would be in person, you ask someone, hey, may I represent you? Or you call them on the phone and say, hey, may I represent you? Or maybe you're on Skype or FaceTime or something that's live like I am with you right now, and you say, may I represent you? Okay? You're not allowed to ask people that because they feel like that puts too much pressure on them unless you have a close personal relationship with them. So you can ask your family or those you have close personal relationships with. You can ask other lawyers, and you can ask former clients because they already know you. Okay? Other than those people, you cannot live solicit anybody. Now, let's talk about soliciting in writing, either through email, text, or a letter. Okay, that's less pressure on the recipient because they can get it and ignore it or read it or do whatever they want. So you can solicit first of all, anybody in the first list, so you can solicit by mail family or people you have close relationships with, lawyers and former clients. But if you're going to solicit basically people you don't know in the mail, then if it's a letter being sent in an envelope, it has to say the words advertising material on the outside of the envelope. If it's a voicemail, an email, or a text, or any other kind of not live solicitation, then you have to state the words advertising material both at the beginning of the voicemail or the email or the text and at the end. A notice of relocation of your office or change of office personnel is not considered a solicitation, so you do not have to put the words advertising material on those letters. So, for example, if you're sending out a flyer that says, we've moved our office to, 123 Maple Street, and Sarah Smith has become associated with the firm, and Sarah Johnson has made partner, that's not considered solicitation, so you don't have to put the words advertising material on that. All right. In your advertisement, you cannot say that you're certified as a specialist in any particular area of law. So you can't say you're a certified estate planning attorney or a specialist in estate planning unless you're certified by your state bar or the American Bar Association. You can say you practice in whatever area you want to, or that your practice is limited to criminal defense. That's fine, but just be careful with those words, certified as a specialist. It's very difficult to get a real certification, so you can't say that you're certified unless it's actually by your state bar or the ABA. So, for example, let's say you went to a DUI course with the Polk County Sheriff's Department, and you learned about DUI. You can't say you're certified as a specialist in DUI because getting that certification from a weekend class at a police department is not anywhere near meeting the requirements that the bar would require for you to be certified as a criminal defense specialist. So just be careful if you get a question. You can't say you're certified as a specialist unless you really are by your state bar. All right, firm names. You can use trade names. So, for example, let's say you're Bald. You can say, I'm the Bald Lawyers Law Firm, or I'm the Redhead Lawyers Law Firm. That's a trade name. And that's fine. I was kind of surprised, but that is fine. If you want to use a geographical name, so you want to say you're the Duval County Law Firm, then you need to have a disclaimer that you're not a public legal aid agency, because so many public legal aid agencies use those geographical names. It can be misleading to the public. So if you want to say I'm the Duval County Law Firm, you just need a disclaimer that you're not a public aid agency. You can't use the name of a public figure who isn't currently practicing in your firm. So, for example, you can't say you're the Barack Obama law firm if, let's say, he was in your firm, but now he's president and he's not practicing with your firm. So his name has to come off the door. Or if one of your partners, who's one of the named partners, becomes the governor and they're not practicing in your firm anymore, then you have to remove their name from your firm name while they're not there. You also can't use the names of people who've never practiced in your firm. So you can't say you're the Abraham Lincoln and George Washington law firm if those people never practiced in your firm. However, you can use the name of deceased lawyers who did practice in your firm, and that's very commonly how law firms are named. So, for example, Holland and Knight, Mr. Holland and Mr. Knight are deceased, but of course the firm can still use their name because they did practice with the firm in the past. All right, Rule 8.3, you must report the misconduct of other lawyers that raises a substantial question as to their fitness to practice law or as to their honesty or trustworthiness. So just remember, your duty to report other lawyers is mandatory. It says must. So if you find out another lawyer is not fit to practice law, you must report them. Okay, Rule 8.4 is kind of an umbrella rule that if they can't discipline you under any other rule, they might catch you under 8.4. It basically says you must be fit to practice, and you can't engage in crimes involving dishonesty or fraud, or violate or attempt to violate the model rule. So, for example, getting one DUI is probably not going to get you in trouble with the bar because that's not a crime involving dishonesty or fraud. However, cheating on your tax returns or embezzling money are crimes that involve dishonesty or fraud and are going to subject you to discipline by the bar. As far as, and notice, it doesn't say that you'll be disciplined for attempting a crime. So you actually have to commit the crime. But as far as violating the ethics rules, the model rules, it says you can be disciplined if you violate the rules or attempt to violate the model rules of professional conduct. So if you've got a question where somebody tried to violate one of these rules we discussed, but they failed, that attorney would still be subject to discipline. All right. The other body of rules that are tested on the MPRE is the Code of Judicial Conduct. It's divided into 4 canons, and you'll probably have about 5 questions out of the 60. Well, probably 5 out of the 50 that count that are from the Code of Judicial Conduct. So you want to make sure that you're familiar with the Code of Judicial Conduct. In order to pass the MPRE, you need to get between 32 and 38 questions correct of the 50 that count. And the reason we can't say for sure how many you have to get correct is because depending on how difficult or easy the exam was, it differs. Generally, about 20% of people don't pass the MPRE nationwide. So if you had a very easy test, you would need to get more questions right in order to be in that top 80% than you probably would if you had a very difficult test where people missed more questions. But the general rule I tell people is when you're doing practice questions, you want to be getting in the high 30s correct out of the 60 on any given. Most practice tests are 60 questions because the MPRE is 60 questions. And if you can get to where you're getting 40 of them right, you can feel really secure that you're going to be fine. At a minimum, you want to be above 35, but to have a real sense of comfort, try to get 40 out of 60 correct on the practice test, and you should be in really good shape. So the Code of Judicial Conduct is divided into 4 canons. The major substance of the questions will come out of Canon 2 and Canon 4, so I'm going to cover those. Canon 2 talks about judges' judicial conduct and when they have to disqualify or accuse themselves. So under Rule 2.11, it states that a judge must disqualify him or herself or recuse him or herself, those words are synonymous, if the judge is biased against the party or a lawyer. Okay, so let's say a judge's mother was killed in a Ford rollover accident, and the judge thinks Ford treated the family terribly and really doesn't feel like the judge could be fair to Ford Motor Company because the judge is biased against them. Then the judge has to recuse herself, and the parties can't consent for the judge to stay on the case. So if it's bias of the judge is out, and the parties, even if they wanted the judge to stay, cannot consent to the judge staying. Anytime a reasonable person would think the judge's impartiality might be questioned, the judge must move to disqualify herself. And then in any of these scenarios, the parties can decide whether the judge can stay. But if the judge thinks a reasonable person might think a judge couldn't be impartial, then the judge has to put on the record, hey, for this reason, a person might think I can't be impartial, and then the attorneys for the parties get to decide whether the judge stays. So let me give you an example. Let's say you're a judge and your very best friend is the lawyer for one of the parties. Okay, you need to disclose that and give all the basis for the disqualification. Say, hey, this is my best friend since I was 8 years old. And then the parties need to decide if you can stay. Now, there's a part of the rule that says if you are related to someone who's coming in your courtroom as a party or a witness or a lawyer, you've got to disclose that on the record. This would be whether you're close with the person or not. So anyone who's coming in a judge's courtroom who is related to the judge or the judge's spouse or domestic partner within the 3rd degree, or is the spouse of those people, has to be disclosed. So the 3rd degree is everyone except your cousin. So if you go up, it's if you, your parents or your grandparents, or you, your children or your grandchildren. So you go up 3, down 3. Or your siblings, your brothers and sisters, your aunts and uncles, or your nieces and nephews. If they're coming in your courtroom, you've got to disclose it. Or if they're any of those people's spouses, or any of those people who are related to your spouse, Okay, so any of your relatives or your spouse's relatives or those relatives' spouses, okay, if they're coming in your courtroom, you've got to disclose it, even if you don't know them, okay? And then the parties go off in private with their attorneys and they decide whether the judge can stay or not. And if the judge feels like the judge can be impartial, then the judge can stay on the case. And then in addition to that, anytime somebody might think you're biased because, you know, maybe you have some personal interest in a case that would make you impartial, then you need to disclose that on the record and let the parties decide whether or not they want you to stay. If the reason you're out is because you're biased against the party, then you can't stay even if the parties wanted you to, as I stated before. All right, Canon 4 is the other most tested part of the Judicial Code, and this talks about judges' permitted political activities. The bottom line is judges can't be involved in politics at all unless they are running for election to be a judge. Okay, so if they're not running for election to be a judge, they need to stay out of politics, meaning they can't endorse parties. They can't make contributions to candidates' campaigns. They can't go to fundraisers and buy a dinner. They just got to stay out of politics. However, if they're running for judge, then basically they can do anything any other politician can do. So they can endorse other candidates. They can give money to their campaigns. They can go to fundraising dinners, and they can do all that sort of political activity because they're a political candidate. All right, well, that is kind of a rundown of some of the most heavily tested topics. Are there any questions? Oh, well, I don't see any, so that's good.
I don't see any questions.
I will receive my golden ticket, which is a really good outline of the course. And I really recommend you listen to the MPRE lecture. It's by a guy named Paul Lisnick, and he's pretty entertaining, and I think you'll learn a lot. And as you're watching it again, go along and fill in the outline that is going to be emailed to you. And I think that'll give you a really good basis to get ready for the MPRE. So with that said, I'm going to turn it back over to Natalie.
Thank you so much, Professor Scales. That was an awesome presentation. Moving forward, here is our contact information for anyone who has any questions or concerns. The Dean ID information is there, as well as Anna's, Amber's, and myself. Stay tuned for our next faculty student hangout. It's on Tuesday, November 1st. It's also on any meeting, so make sure you're registered for that at the link below. It is with Professor Karen Millard and David Simon. Top 10 things to know about the U.S. court system. And then the next speaker series is Wednesday, November the 9th at noon Eastern time, also online with Professor Helsing. And it's regarding the bar exam, and so make sure to register for that as well. And finally, one last thank you to Professor Scales for that presentation. And be sure to like our Facebook, Florida Coastal U.S. Law LL.M. We did take a few pictures, so stop by and take a look at those. And with that, we thank you one last time for joining us. And once again, thank you, Professor Scales, for that presentation. Everybody have a great day.
Thank you. Bye-bye.
Bye-bye.